Hello, hello, hello. This is Attorney Mike Gravel coming to you from Chicago as usual. And yes, Iris, it worked. You owe me $5 now. I got some clips that are so good. I had to late night stream impromptu. I have to thank Kristen for this debacle. It's really her fault. But Natalie's also got part of the blame. And also an anonymous source. Oh, wow. This is so good it inspired me to give a tribute to AC/DC. That's how good this clip is. It's too bad I didn't have it for my intimate shave stream that I just did, which by the way was fantastic. You really need, if you haven't seen it, you need to see it. And even if you have seen it, you need to go over there and check out the posted comment from Fat Man. It gave me a good belly laugh all by myself here. It really did. All right, it's late. Let's get this party started, shall we?
Ma'am, you didn't say the cat jumped on his wiener, did you?
Any objection?
All objections.
The family unit or the existing or proposed custodial home, and I want to talk about that briefly.
Oh, yeah, it's from the same call as Intimate Shave. Where's this call been my whole life? With Judge Hagen there, who's also fantastic.
Do you have any pets at the marital residence?
Yes, we do.
What sort of pets do you have?
We have one cat and 2 dogs.
And what's going to happen to the cat once the divorce is finalized?
Copper's coming with me.
What's going to happen to the dogs?
The dogs will also be coming with me.
Are the children bonded to those pets?
Yes, they are.
Ms. Kloosterman, in the defendant's referee status conference brief that was filed on July 11th, 2023, the defendant accuses you of obtaining the dogs in an attempt to buy the children's affections. Is that true?
Absolutely not.
Can you explain why you obtained the dogs?
Yes. Our entire marriage, I have been pleading for a dog for a short amount of time. In 2015, 16, we had one for a few months. It was always a point of contention for us.
I mean, we love dogs here at Law Talk with Mike. I know we're big dog fans in the chat and all that. But I think she might like dogs even more than us.
Kevin doesn't like dogs. He doesn't like what they do to his yard and his line of work. I understand that. However, our children and myself, again, not hearsay, myself have always wanted a dog. Grew up with a dog. I think dogs are wonderful. In my classroom, therapy dogs, right? My goal was always to have a therapy dog for my classroom. Throughout our marriage, however, Kevin would not allow us to have a dog. However, it was a huge point of contention, and the fact that there was times where I would do sexual favors for him or other male friends of his in order to, per se, earn a dog. And so it was my understanding that if I were to complete this task, that I would then be allowed or permitted to get a dog. Multiple times, many times, that was not followed through. And so and then a few months after he had left the house, I decided that this was the right time and I needed companionship and something to occupy my time with. So I got the 2 dogs.
Please, oh Lord.
Get the camera.
Cut that camera, please.
I'm just piecing this together. Is it the same hearing? Was that from the same hearing that I did earlier?
Mr. Tang, because I don't know what's about to happen there.
I'm going to use Miss Fowler's words. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
Ma'am, are you a whore?
I object to the relevance of that, Your Honor.
All
right. What?
I'll tie it up real quick, Judge.
All right, go ahead.
You're not a whore?
Can I say the words that she said, or?
Sure. I need for you to tell me what went on.
That I'm not on that whole shit. I'm not with that whole shit.
Up to you. I'm happy to get things done for you. So I've got, Ms. Simmons, I've got on one case Stipulate order continuance, and on the other plea?
That's correct. And one of those charges
Okay.
that 3 are going to be
All right.
dismissed.
So, Mr. Sitzma, why don't you don't mind, Mr. Eastwood, if you could hand these to Mr. Sitzma, you can give him this pen and you can kind of wander through those. Great. Okay, I'll keep it. And just give you a chance to review that, and you can sign it when you're ready, and then we'll talk some more about it. So have a seat right there, and
Okay, we went completely over this, but
if you're ready to sign it, sign it. I
Yes.
just want you to
you know
make
what, I'll
sure
sign
you
this and then I'll
see.
go home and get the money and get it back.
Just sit down and sign it. Look
Okay.
through it all. Look through it all, and I'll come back to you. No rush. We're gonna get.
Oh, this takes a while, but he reminds me a lot of Anthony Carmona, the guy that Judge DeSanto had to tuck back from the ledge. He is like out there, and it just gets really awkward.
Get it done if you want to, but I just want you to know
Yes,
what
ma'am.
we're doing. And then let's see. Is there something to know on the Howard matter?
Elements are.
Mr. Coker, did see here? Request to continue filed by Mr. Coker. So moving to the Howard matter at 10 o'clock. Mr. Coker filed a motion to continue or to.
I believe, Your Honor, I received an email regarding that case. I can just pull it out.
So what he's asking is to strike the trial dates, which are set, till October 25th on one, October 23rd on the other, resetting, and so forth. All right, so he's asking for that. Looks like you've talked. And then there's another case set for confirmation November 22nd for Mr. Howard.
Yes, Your Honor, I did receive communication from Mr. Coker, looks like earlier today, asking to waive his and his client's appearance today and setting out a pre-trial 30 days, despite the current date.
Okay, and then, all right, so what if we, so everybody wants to continue, both sides grant the states, grants defense. So on those matters, the case, the DV, 23 DV 723, we're in excluded period, granting the continuance for good cause. The case 3A 523-846, granting continuance, we're in an excluded period. We'll set all of this to November 22nd. That confirmation and jury trial on those, but keep, so the other one, 23 DV 735, we'll keep it set as it is.
Okay.
But try and track all these together, I guess is what I'm saying. Our next court date would be November 22nd, and that might be a good day to do confirmation for all of them. Let's see what calendaring can do, and then we'll send out notice. All right. And then got that. All right, so looks like maybe we've got some traction on Mr. Sitzman's matter. Mr. When you're ready, Mr.
Just filling in the paperwork and I was going to sign it.
Okay, you just need to look through things. All right.
Are you the prosecutor?
Yes.
Oh, Jesus. We're not friends, are we? I'll be darned. I bet you got razzed a lot about Eastwood, right?
Right.
The last name was, it's striking, right? Because of that name. I changed my name to Clint just
Oh, the more he talks, the better it gets.
to be a nickname in the family.
So Ms. Simmons, while Mr. Easter's looking through things, what is the plan here?
It is to plead guilty to one count of a no contact order violation on the 21 DV 0521, dismiss the malicious mischief, and then to enter an SOC on the other matter, the 17016, which is a no contact order violation. It's a 12-month SOC. And
Okay,
then,
all
and then
right.
it will be restitution on the matter that Mr. Sitzman is pleading guilty to.
Okay. All right. I think I understand. So, Mr. Sitzman, let me go through all this with you. Make sure that you understand what you're doing.
Well, yes, ma'am. Go
All
ahead.
right. So you're pleading guilty. Well, you're pleading guilty to one count of violation of no contact order from May 26th of 2021.
Was there-
And then the other one, May 23rd of 2021, you're entering this kind of contract
Yeah.
with the hope that that would be dismissed at the end of that year of probation. So one will go on your record absolutely with a plea of
I
guilty.
know.
The other would be potentially a dismissal if you follow your side of this contract.
What would be the process? How long before I could get my gun rights back so I can go hunting?
You would have to ask the Superior Court for that right back. I don't control that. Yeah.
Not
You
as
would
long as
lose
this
that
is
right.
happening.
You would lose that right throughout this.
Right.
Definitely. If you successfully complete.
That's always the first thing you ask when you're entering guilty plea is when do I get my guns back?
All this, if I go along with this,
I will.
you successfully complete it,
I will.
then you have to go to Superior Court and write a petition and say, can I have my gun rights back? And then they evaluate it under the law and decide. So.
Would it help if I had somebody sign like Kayla Wilcox?
No, I have no control over that. It's Superior Court.
Yeah, I think it'll work out.
Well, let's go through it and make sure.
Yeah.
As we go, I think he low-key hits on both the judge and the prosecutor. Or is that a defense attorney? Whatever, the attorney.
This is what you want to do.
Well,
let's just go through it. And then you can ask questions. You can tell me at the end if we're doing this or not.
It's been
It's
so
up
long.
to
It's
you.
been 2 years of this.
Don't ruin
crap.
it for me.
Call me
Katie.
Judge Wilcox
Oh,
or Your
sorry.
Honor or something like that. All right. I'm
Just
calling you
slipped
Mr.
out.
Sitzma.
I
That's
think
what
it's a
we
really
do
cool
here.
name.
When
So,
I see you in the grocery store over the avocados, you can call me that, but not here. All right.
yes, ma'am.
Cool. All right. So let's go through this. First off, feel you had enough time to talk to Ms. Simmons to make this decision.
Pardon me?
Have you had enough time
Yes,
to talk
ma'am.
to your
That's
attorney?
why I was out there for a while. So,
Yeah.
Like telling the fish.
I'm going to
not
have no
swim.
problem with this other than I'll just skip a year of hunting. I just want this out of here.
But you've had enough
All right, Judge, I'll skip a year hunting.
time.
Yes, ma'am.
Okay. You're ready to make this
I
decision.
know.
Good.
Yes.
And then all your rights. You have rights to have a trial. You understand those rights?
Yes, ma'am.
Okay. And you know you're giving up those rights to a jury trial if you enter these agreements.
Am I going into a trial? I thought this was.
Well, everybody who's charged with a crime has the right to have a jury trial. It's up to you.
I
You
thought I'm
make
paying
that decision.
$500 and agreeing to do nothing wrong for
Slow
2
down.
years.
What
And
I'm
then
telling you is you have that right. And you can or can't. Nobody can decide for you. You make that decision. And today you're making a different decision. And that's why I want to be sure you know that you have that right to go to trial if you wanted to, that nobody's making this decision for you, right?
I do not want to go to trial. I agreed to $500 and I'll agree to the probation period that until this is done. And then I'll move on again.
Okay. So,
I'm
you're
not going to trial or
okay.
anything.
So, you're giving up your right to have a trial in these cases if you plead guilty or if you enter this agreement.
I'm tired of it. Yeah.
I'm feeling that. All right. So, in a plea of guilt to that violation of
I'm feeling
contact
it.
order, if I accept that, then we're dismissing the malicious mischief.
I'll go get the money right now.
Just slow down.
Okay.
You understand, it sounds like you have a full understanding of
Yes.
what the recommendation from the lawyers is.
Yes, ma'am. She was
Okay.
very thorough.
So now let me ask Ms. Simmons. I see Ms. Simmons on the plea of guilt. This is a 24-month probationary period, and the other is a 12-month probationary period. Is that the plan?
I get that feeling. But he
You're
swears he hasn't
muted,
drank
Miss
for 2
Simmons.
years now.
That was what the offer was, Your Honor.
All right. And so that's the agreement? I mean, do you understand
Honor.
that the plea of guilt?
Can I ask you a question?
If I accepted your plea of guilt to one count of violation of contact order, the lawyers are asking me to put you on probation for 2 years.
No,
On the other one,
I've been there for 2 years
if I
already.
did this contract, this stipulated order continuance, they're asking that just lasts a year. So you understand that?
Yeah.
The court doesn't have to go along with these recommendations?
Yeah.
Okay. So I'm going to hear from everybody at sentencing. I'm going to hear from the prosecutor, hear from the Simmons, hear from you at sentencing. So
So
the
we will-
maximum possible sentence I could impose at sentencing on this violation of contact order DV could be 364 days in jail and a $5,000 fine. And you know that.
Yes, ma'am.
I could also do differently than this recommendation. You know that. So I'm not bound. And the stipulated order of continuance is a little bit different. This is an agreement. It's a contract you're making with the help of your attorney with the state.
Is that what, like a plea agreement? Is that what you would
Well,
call
this is
it?
all a plea agreement. One, you're pleading guilty. Guilty finding goes on your record.
Yes, knucklehead. That's what we'd call it.
I know.
The other, we wait.
64 years old. It can't let, I don't see where it's going to harm me. That's why I just want to pay the money and leave. I've already done almost 3 years of probation as it is before this even came to here.
So the contract, though, I don't get to futz with that, really.
What?
I don't get to change this
terms.
contract.
She threw him with futz. I didn't catch that the first time. That's funny.
To this agreement, because I'm
good with it. I'm not doing anything. I know it's a waste of my breath. What I'm in here for, I did not do.
Well, and I'll ask you some more questions and make sure. I mean,
But
because there's lots of reasons to plead guilty. There's lots of reasons to enter contracts. I just need to make sure. This is my goal. And with you is to make sure that you're doing this voluntarily, intelligently, and knowing the consequences. That's what I have to be sure of. So that's why I'm asking you all these questions. And you're going to tell me one way or the other.
I'm going to tell you, I pay the $500 and everything goes cool for the next wherever they got. This is gone.
Yeah, if you agree to that contract, this gets dismissed. One goes on your
that.
record.
I would
one
like
gets
that.
Dismissed. Okay.
I certainly don't want to sit in front of 6 to 12 people and try to explain myself of something.
Yeah. All right. I'm hearing you. So,
The first good thing you've said all night, because you're not gonna. That wouldn't go well.
a couple other questions I have to ask. This is all stuff I have to ask.
We're here.
So I'm not doing anything I wouldn't do with anyone else. And I'm
It's okay.
I'm glad you're responding and letting me understand so I can make that finding. And that's what I have to do. Are you doing this knowingly, intelligently, and voluntarily? That's where I'm trying to figure
I think
out.
it's the best outcome.
And that's what I'm hearing from you. All right. So,
That's what I'm hearing from you is judge for close enough at this stage of the call.
it's pretty clear, that if I accept your plea to this violation, no contact order, domestic violence, then you lose your right to possess a firearm. Obviously, you understand that. And that this court doesn't give it back to you, that even when we're all done here, even if you get that dismissal, you still don't get it back.
I have to come back here to
You got to go to
reinstate.
Superior Court and say, can I have it back? And
But
then
we can
they
still
make
say
that.
hi in the grocery store.
Yes.
All right,
You can say hello in the grocery
I'm
store.
good with it.
But you'd have to go to Superior Court and ask them. All right. So it doesn't come back automatically. All right. You know that.
You would do the same thing.
Okay. Well, all right. So then I've asked you to make, on this plea of guilt, a written statement as to what you did wrong that makes you guilty. And what you're saying is that exactly that. On May 26th of 2021 in Thurston County, you did violate a valid no contact order with a Marlissa Sitzma. Now that's what you're admitting to. Should I accept that statement?
I was there. I went there because she asked me to.
Okay. So
I didn't
that,
know. I didn't know it was a setup.
Yeah. So when you plead guilty, that's the statement you're making.
I know.
Can I accept that or not?
Yeah.
Okay.
I mean, let's just.
So has anyone threatened you with harm? Has anyone made you any promises to get you to plead guilty or enter this agreement?
No, I just think it's the best choice I can make. I just want to start living.
I'm hearing
That's it.
All right. So that tells me it's voluntary. No one's.
Yes, ma'am. Nobody's told me to have to do anything.
Okay.
I wouldn't
All
allow it
right.
anyway.
Good. And the sum total of the requirement here on this agreement to get the dismissal is stay out of trouble, don't possess that firearm, and no contact order. You follow that no contact order. I heard about, Ms. Simmons heard about restitution. I didn't see that in here. Is
That's
that
the 500.
okay?
Yeah,
So
no,
that's
that's a part of the agreement for a broken
I
fence.
paid $200 for that cattle gate.
500 for the fence. Okay, so you've agreed to that. And then to stay away from her, don't possess firearms, stay out of trouble, this also, I'm asking the attorneys here, it also says don't consume alcohol or drugs in the plea of guilt.
I don't drink any longer, ma'am. I went through alcohol,
Yeah.
and it was because of this. I don't drink.
So is that, and you remember,
she holds a pamphlet that shows that I came on my own and I completed it, and it's the best thing I ever did.
good, I'm glad.
Yeah.
But you know, that's part of this agreement.
What?
Don't stay sober. Do stay sober. That's part of the
It's
agreement.
been, what?
Not a problem.
February 2nd, it'll be 2 years, and I'm not looking back.
Okay. So, I don't think you have any other questions about this.
No, ma'am.
Okay. Well, I'm going to go along with all this. I'm going to go along with accepting your plea of guilt. It's clear you're doing this voluntarily, intelligently, and understanding
It has to be
consequences.
done.
And I'm going to accept your stipulated order of continuance. So we'll be able to get one of these dismissed by October of next year. And the other,
It'll just drop off. Well,
I'm going to pretend not to notice that you're likely wasted so that this that this plea takes.
come here and
no,
okay.
you don't have to
You
come
don't
back.
want me here.
We may send you a note for a final hearing. You don't have to appear. If anything happens, you know, you violate the law, you violate the no contact order, you possess a firearm, don't pay your restitution, then we'd haul you back to court and say, what's up?
If I can't make it back today, it'll be
Water.
paid tomorrow.
That's fine. I'm going to give you a time on that.
I don't like this side of town.
Okay. So now I have to put things to writing, and I'm going to go along with your agreements here.
Thank you, ma'am.
So, and then you'll just, you can pay it all off whenever you want. But I'll just say within 30 days, you sign a time payment agreement at least. All right. So let me pay attention to this. I'm dismissing the malicious mischief on 21 DV 521. And give me a moment here. We're going to give you a lot of paperwork here just to show what I've just said. And is there a post-conviction no contact order and an order informing Mr. Sitzma what he already knows about, that he's lost his firearm rights? Mr. Eastwood, need those 2 forms.
I will have to work on that, Your Honor.
Okay, well, I'm working on this, you work on that. We'll get Mr.
I don't
Eastwood
want
on
to
his
meet him in
way.
the grocery store.
I think he's fine.
Judge wants to work in this order.
Oh, you know what?
Yeah. You know that kid that was just up there?
Yes.
Screen?
Give me a moment just so I can pay attention to what I'm doing, and we'll never get out of here.
Shut up.
My next door neighbor to lunch. She's 90 years old.
Still going.
What bugs in her ass?
Your Honor, I apologize. My Laserfish is still not working correctly, and the previous form that I tried to do the clerk has informed me, messed things up. And so I believe Madam Clerk has suggested that she might be able to produce some of those documents.
Thank you. It'd be great.
Given my technical issues.
Grounds.
Thanks for not helping while I'm dealing with crazy. I really appreciate that, counsel.
The
Just the post-conviction one.
Don't worry. The cringe is not over yet. There's more. He's just getting started.
That's right. Well, then just put it on the 521.
Another shout out to Natalie D for bringing us this debacle.
By now. There it is.
I've got the evil villain guy. I've got to follow up on him if you guys are interested after this. But I haven't seen it.
Yeah. We're getting close. I'll be on your way soon. More paperwork. We'll get there.
Do I have to, am I signing it or something, or is it just?
I'm just going to hand you all this information, the notification that you've lost your firearms rights, my judgment and sentences, so you have that. And then just a final copy of the no contact order, so you have everything. I mean, all of this will also be in the court file available for you if you'd like to go through your Zoom instructions and do that, or talk with your attorney, or, but might as well while you're here, let's just get it all to you and you'll have you off in a couple of minutes.
I agree.
Okay. And everything else. Oh, thanks. Okay.
I can't help but laugh when I see her. She's a pretty good attorney. You know it.
Glad to have her.
She can't hear me, can she?
Yes, she can.
Oh, Jesus.
Yeah, glad to have her there, crazy.
Yes, Zoom captures all, Mr. Simpson.
Boy, am I in trouble. Just think none of us would have got to meet if this wouldn't have happened. So there's a blessing in disguise here.
I can think of it that way.
I was going to ask you.
1 second. Let me just, I'll get this done and then.
You're the one holding this up?
I'm the one holding it up right now. Yeah. Done, Sue.
We got it.
The prosecutor.
You're never going to see me get it.
I don't know.
I can't do that.
Yeah, this isn't going to let me do it either. I think the best thing we can do is print it out. It just, the computer won't give me the access. So if you could print out the one that you just tried to give me, then I can get there faster. It won't let me access it. I mean, I can't.
Oh, this is Washington. He's got to, ask her if she's going to give him hard time or something like that before we get to contempt
Old
here.
school.
Didn't have to do that stuff.
Nothing wrong with that, Your Honor.
Thanks. It's amazing me.
So what store you shop at?
Oh, it's bad. I forgot about that.
Hey, Jerry.
Yes, Mr. Sitzman.
Tomorrow, will I be able to call you? And I'd like to see you tomorrow. Is that possible? Do you have an opening?
Maybe we can,
Can you squeeze me in?
I can talk to Ian after court, Mr. Sitzman, so court can proceed. I'll have him reach out to you.
I can't take it.
Okay.
Okay.
All right. Yes. I'd like to know what that's all about. Julian Musket. Oh.
All right. I am no longer holding up progress.
You did it. Yeah.
Well, you did it. So we got you going now. All right. So we'll
Touche.
hand you everything. And then don't come in for trial. We canceled all that.
Ma'am, I don't have to come back at all, right? Other than pay that money tomorrow.
Yes.
I'm good.
Okay. All right. So, and then Ms. Simmons, you're going to be in touch with each other.
Hey, can I ask you about that Dylan kid that was on the screen? You want me to grab that stuff?
Yes. There you go. This is yours. Thanks, Mr. Eastwood.
Anyhow, did they have a good kid? He seems to look like a good kid.
Not for me to discuss all that. All
I
right.
was just wondering if they have programs and that sort of thing.
There are lots of programs to help folks. Yeah. So I'm hoping. All right. See you, Mr. Sitzma.
Nice meeting you.
Nice to see you again. Thanks.
See you later, Vera. I'll call you later.
Thank you. Thank you, Your Honor, Mr.
Ms.
Sitzman.
Simmons,
Mr. Eastwood.
any other clients?
No, Your Honor.
Okay. Thanks, Ms. Simmons.
Thank you, Your Honor.
Holy wow. That's magical.
How's that, Your Honor?
Okay, there, we can hear you.
All right. First of all, you guys cracked me up. I said that this guy looked like a villain, and he shows up like a villain again from the last one. Literally, I got so many villains on there, and he looks like all of them.
Okay. So, and then, is it Ms. Reed?
That's right, Your Honor. I'm attorney for Pope Resources.
Okay, great. I'm
You're
just hold on 1 second, sir. I'll come to you in just a second. I'm just going to make sure, since I was not the judicial officer previously hearing your case, I just want to make sure I'm on the same page with everyone else. So, as I understand it, the plaintiff has filed a motion for summary judgment. It was set for last week. There was a request by the defendant for a continuance at that time. The plaintiff objected. There were some service issues. Ultimately, the judge set it over to this docket. Since that time, I have received, sir, your motion to dismiss summary judgment with prejudice.
Why is he out of frame?
So what I believe has happened is, well, I guess I shouldn't presume, but my hope is that both parties have received copies of what the other parties have filed, and that we're proceeding today on argument regarding plaintiff's summary judgment motion. So I'll start with Ms. Reed. Is that correct to the best of your understanding?
No, Your Honor, we haven't inserted anything, including the previous motion for continuance. I've received nothing from defendant.
Okay, so you have not received his motion to, he calls it a motion to dismiss summary judgment?
No, I have not seen that.
Okay. So, sir, I'll turn to you now.
Your Honor, I have express United States Postal Service receipts that were sent the day of the first hearing, and I have 2 more United States Postal Service receipts that were sent yesterday on the 17th and today. And I've also sent them by email, which they say they cannot open. But yet, it's strange that I'm able to receive their email. That was all discussed at the last hearing. I've been sitting in this booth for almost 3 hours now, according to the time that Judge Basher gave me. And I request holdover until November 8th, because I've been listening to all the cases that have been hold over to Judge Basher on November 1st. I would like Judge Basher to hear this because he heard the preamble and the reasonings for the continuance and the motions and so forth. I do not believe the opposing client or the opposing, excuse me, Your Honor, I've been in this booth for 3 hours now. I do not believe the...
And he was slow when it started.
Law firm representing Hope Resources is genuine on their comment. So I again request a holdover November 8th. That's all I have at this point.
So Ms. Reed, you haven't been served the motion to dismiss summary judgment with prejudice supplement. It's a 3-page file.
Okay, I mean, I know this is late, but you don't file a motion to dismiss a motion for summary judgment. You file a response to a motion for summary judgment. This guy does not get it, and he thinks. And I wouldn't beat him up so bad, but he's so damn condescending, and he is clueless.
Filing by defendant with some attached pictures. What are you requesting of the court today as far as how you want to proceed?
Your Honor, we would like to proceed to have this matter heard today. Defendant was timely served with a complaint in May of this year. He was timely served with the motion for summary judgment. We've had one holdover from last week regarding the service issues that were described that you mentioned. The actual motions and pleadings were timely served on defendant. We simply had to send an updated form of the note for motion to include the Zoom information. So it's our position that defendant has had ample time to review the pleadings and to file a response. I've also had no opportunity to review any of the materials that defendant has filed, either the request for continuance or this request to dismiss. We believe I believe it should be heard today. There's plenty of time for him to consider it, and my client is really anxious to get this matter resolved.
Okay. So I guess my question for you is, so you're not asking for additional time to see his response. You're wanting to proceed even without seeing his response, but it's your request that the court or essentially that the court disregard his filing in response? Or
That would explain a lot.
Sorry, if I can clarify. The request would be that the court disregard the untimely response to the motion for summary judgment. If the court is going to consider the response to the summary judgment motion, we request to have an opportunity to respond in writing to his response and file a reply. I would note that we will need to be served with the document.
Yeah. Okay, that helps me out. I wasn't sure if you were wanting to waive your right to see it, assuming I take it into account. So here's my ruling. Hold on, sir. I'll come to you in a minute. Everyone will have more than one opportunity to talk. Here's my thought. I understand when one party is represented and one party is unrepresented, going through legal proceedings, it can be very complicated. It can be very difficult. Well, you can shake your head, sir, but I'm about to say, technically, you didn't serve your response timely. But I, sitting in this capacity, have equitable powers to say, hey, I think that's excusable. You're not represented. This case was set over, was set over for service issues. And I do believe that you have the right to be fairly and fully heard on this issue. All right, I need to take a sip of water. So I do believe that the court should consider the filings that you have made for whatever relevance they may have. The court is not making any rulings on the admissibility or relevance of these responses, but you have filed a response with supporting documents. So I don't want to give a whole ton of time for this to happen, because we do need to move on with this. But I'm not understanding the faces, sir, that you're making to me. Can you explain again?
Your Honor, the reason I'm making these faces, I'm dead tired. I've been in this booth going on over 2 hours, and I'm tired. And it's not air conditioned. I'm not in judges' chambers. I'm not.
Well, then get an attorney to learn how to practice law, because these continuances and delays are your fault for not knowing what the hell you're doing.
In an air conditioned law office. I've been in this booth over 2 hours now, and I'm fatigued. That's the reason.
Boo-hoo.
Okay. Well, here's the deal. Court dockets run for 3 hours. So our civil docket can go until 5 p.m. So we start at 2, we end at 5. So I can't put people in front of other people. You just wait your turn when a case is called. So I can't fix that for you. And it's going to happen again. Whatever court date I give you, you have the very real chance of waiting. I've had civil dockets that really are 3 hours long. Luckily, this one's only going to be an hour to an hour and a half. So
you could call a ambulance.
I can't fix that for you, but I am asking you to have decorum in a court. I know you're in an iPad booth, but this is a court. This is a courtroom. So I'm I need you to give the court the respect that it deserves. The eye rolling, the shaking of the head, that doesn't fly with me.
Like I said, Your Honor, I've been in here 2 hours. I'm fatigued.
Yeah, we've heard.
I apologize for any decorum that's unacceptable.
I am going to allow one final continuance at the request of the defendant, but also taking into account that he has belatedly filed a response that I do think the plaintiff should consider and have the opportunity to respond to. But the defense needs to serve that response on the plaintiff. Ms. Reed, how do you want that service to proceed? Do you want it by email, or are you asking for regular service?
Regular mail.
Your Honor, we do not want it by email. I cannot access the email system that defendant is using to email me. So service by mail. I would ask, Your Honor, if we could set some deadline for the date at which we will have received his reply, and then a deadline by which we can file his response, and we can file our reply, just so we have some firm dates in the calendar for that.
I think that makes a lot of sense in this scenario. So, sir, when can you get those documents mailed, or have you already mailed them?
Already mailed them, Your Honor.
Okay. So, and when did you mail them?
I mailed them on the 17th by express mail, next day delivery. I mailed my amendment to the motion to dismiss this morning when the post office opened at 8:30 by express mail, next day delivery.
Okay. Understood. Just for future reference, you can't put things in the mail and expect it to be deemed served the day of the hearing. Okay.
I understand.
So what I'd like to do is set this out. Ms. Reed, is 2 weeks sufficient for you, November 1st?
Yeah, I assume if defendant mailed on the 17th or the 18th, I should get that by tomorrow or Friday. So November 1st, 2 weeks will be fine for the set of a hearing date.
Correct. Sir, will November 1 at 2 o'clock work for you for our new hearing date?
Yes, Your Honor.
Okay. So then let's just say if your documents aren't, it's hard to say when they're going to be received. Here's my hope is that did you mail the documents this morning, same day delivery or next day delivery?
The supplement was mailed today at 8:30 a.m. by next day delivery. And
okay.
Here's what the post office guaranteed. It would be in their office at least by 1 p.m.
Okay. So let's say okay, so the deadline then for Ms. Reed to receive those is going to be Friday, October 20th. So, sir, you may want to just make sure that you get confirmations of delivery by Friday, the 20th. And then let's have any response filed, Ms. Reed, by Thursday, October 26th. And I know that's a tight turnaround, but they are fairly short filings, so I don't anticipate you're going to need a ton of time. And then make sure we serve the defendant, and then we will be back here on November 1st, and we will move forward absent some extenuating circumstances. I'm not going to grant another continuance. I do understand both parties' request for some finality on this particular issue. And I do understand it's been pending for some time.
And Your Honor, would you repeat the response for the plaintiff?
The plaintiff will need to serve and file the response on by October 26th.
26th. Thank you, Your Honor.
Yes. Anything else we need to do on this case today?
No, Your Honor.
No, Your Honor. Thank you for resetting that.
Okay. Great. We'll see you back November 1st.
Great. Thank you very
All
much.
right, thank you both.
Oh my gosh, it is a double rainbow. I cannot believe it. It's a freaking double rainbow.
All right. All right. I have one more. It's about 10 minutes. It's the CIA guy, or at least according to him, who rolls into Judge DeSanto's courtroom. But I haven't seen it. Should we do that? What if it's bad? I don't know. All right. Let's try. There seems to be support for it.
It's unmuted now. All right, we are going on the record in the matter of the City of Wyandotte versus Ryan Cheney, 232085, and the City of Wyandotte, I'm sorry, the State of Michigan versus Ryan Cheney, 231802. And appearance, counsel?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Cheney. Mr. Cheney, would you please state your full name for the record, please?
Ryan Michael Cheney.
All right, thank you. And counsel, as to the arraignment on the 232085 matter, because Mr. Cheney was arraigned on the state case and just never appeared back for his pretrial.
Yes, Your Honor. I did have an opportunity to speak to my client this morning regarding the charges, the maximum penalties, and his rights. He did not have any further questions for me. So at this time, Your Honor, we are prepared to waive a formal reading, and my client stands mute.
All right, the court's going to waive the formal reading, enter plea of not guilty for purposes of the arraignment, and enter plea of not guilty.
I don't know.
On your client's behalf, and we're going to schedule this matter for pretrial October 3rd at 8:50 a.m. We do have a jury trial scheduled that day. However, given the fact that Mr. Cheney is in custody, that is the day that we have.
This is an awful reasonable start. I don't know what's going on here.
To give him. And so the court will note on the state case, defendant in custody, warrant recalled, pre-trial October 5th at 9:30 a.m. Okay, and then as to bond, counsel.
Yes, Your Honor. Mr. Cheney currently is working for Equity Finance as a mortgage broker. He's not currently on probation or parole. He does not have any other pending matters at this time that we're aware of.
Good to hear.
And after speaking with him at length this morning, he did assure me that he would be appearing at all future court dates. I did ask him if he was tested today, if he would test positive or negative for any drugs or alcohol. And he did indicate that he would test positive for marijuana, but nothing else would be in his system. And even the marijuana might be very, very slight, as he was taking some CBD type pain relief medicine.
Mm-hmm.
So it probably wouldn't even be THC. It's just the other form. So taking all that into account, Your Honor, I would simply just ask that all that be taken into consideration when assessing the bond.
All right, thank you. Okay, and so Mr. Cheney, your name, please.
Yes, Ryan Michael Cheney.
Okay. And you were arraigned in this matter on the state matter on July 20th, and you never came back. You're supposed to come back August 3rd. What happened?
What happened was what my counsel did say is my civilian job is equity finance, but I also my real job, I've been a 30-year plus CAA operative. My team's attached with like Delta, Navy SEALs, Rangers.
Okay, here we go.
Marine, MARSOC, Raiders, etc. The reason that I did not make that date is because I was deployed, and it was about just over 2 months. I'm going to say 2.5 months, but I can't be exact, but it was just over 2 months. My deployment extended. That is the only reason that I did not make that court date. If I did not extend that deployment, I would have made that court date, Judge.
Okay.
So my civilian
and
job is
you're-
equity finance. My real job is a CIA operative for the past 3, which I'm retired. I contacted the VA last week and I let them know I'm retiring. I'm 49. I'm about it. That's it. I'm done. So that's why I didn't show up for court, Judge.
Okay, do you have anything else that would support, any documentation that would support your deployment, sir?
You could contact Langley, Virginia. They would back that up.
Well, no, I can't contact them. I need you to provide some documentation.
I don't have any documentation on that, Judge.
Yeah, if this was remotely true, someone would have contacted people long prior to this.
That's a no-no. With what I do, that's a no-no. You don't have documentation. But you can contact CIA headquarters, Langley, Virginia, no problem. I couldn't tell you Tom, Dick, Harry, Tina. I have no idea. In fact, I've never been paid, Judge, in the last 30 years. I have never received a paycheck. All my paychecks go to my wife, who is also operational. I was notified she is located in Texas right now. So I don't even know how to get a hold of her. And so, like I said, I don't have, I've never received a paycheck in 30 years. I don't know where I'm, an accounting department, a payroll department. I have no idea. I've been gone. I've been deployed.
Okay, well, this much I believe. He hasn't received a paycheck in 30 years because his fantasy employment isn't real.
Well over 100 times. Well over 100. Well over. So I have no idea.
Okay.
You don't carry paperwork, ma'am. Judge.
I understand. I understand. Okay. I need to get back to that. Okay. And counsel, I'm sorry, yes, Bond?
Yes, Your Honor. Mr. Cheney was living in Wyandotte at 168 Clinton Street. Unfortunately, I guess
His attorney's like, I had no idea he was going to say that. I don't know what to say here. I'm going to pretend it didn't happen.
He was evicted this morning. Again, he's not on probation or parole. He doesn't have any other pending matters at this time. And after speaking with him at length, he did assure me that he would be appearing at all future court dates. So I would just ask that all that be taken into account.
Okay. I'm sorry, he was evicted this morning?
That's my understanding.
The 22nd was my official eviction date. The papers are on, if you walk in to the front door, they're offset to the right-hand side, the papers are there. Because of my deployment extended 2.5 months, I was not able to work civilly here to pay my civil bills, which now I'm evicted, my landlord evicted. And when I came home, my entire house was ransacked. That's a whole other story.
Also not true. but do you want to hear it?
All this is verified. You can go there now.
Yeah.
Like I said, the eviction papers are offset. If you walk into the front door, they're offset to the right-hand side. I set them there for anyone who, would be there.
We don't doubt your eviction. It's the rest of the stuff you're telling us.
The officers that showed up for the warrant were professional. They did a fantastic job. I set that out and I let them know that the only 3 bags I have that I own are the bags that are right near the very front door. My rucksack, my computer bag, and my little tote bag, which I came home with. But other than that, my house is ransacked with a tracking device in the basement. So I don't know how that happened either. So this is my exact situation.
Okay.
All verifiable.
Okay. The court's going to indicate as to case number 231802. The court is going to note that defendant failed to appear for his last court date. did not contact the court to inform him as to why he would not be present. And even as Mr. Cheney's indicated, he was not in the area, and even when he came back into the area, did not contact the court. Therefore, the court's going to indicate a $10,000 10% bond and GPS tethered to the Wayne County Jail. That's the case number 232085, based on the defendant's failure to appear on case number 231802. The court's going to indicate a $5,000 10% bond, GPS tether to the Wayne County Jail. And the court's going to indicate that you're not to return to the waterfront restaurant.
The wheels of justice are going to roll you right into the Wayne County Jail.
Drugs that are not prescribed. Anything else, counsel?
Not at this time, Your Honor.
Okay, and those are your bond conditions as well, sir.
Thank you, Judge.
All right, thank you. Have a good day. Off the record. It's unmuted now.
Ah, well, there you have it. That was a wild ride. That was a wild ride. But it was really all spurred by the Dirty Deeds clip. I had to do it. I had to do it. It was so Law Talk with Mike. It had to be done. I had no choice about it. Then we had the crazy guy hitting on the judge and the attorney. We had Dr. Evil. And then we had a CIA operative. What more do you want? What other channel's going to bring you all that in one day? Thank you all for coming out. I really appreciate it. Good night.